So Andrew Tate is trying to get released from jail before he gets extradited to the UK and cooked. Now, if you saw the video that I uploaded earlier today, I went through all of the paperwork and evidence that they're putting forward against Andrew Tate. He's lied countless times on X and beyond, saying there's no evidence, no evidence, no evidence. What victims? What victims? Well, we just seen a bunch of them, all right? They're keeping their identity secret because you guys keep tampering with the witnesses. You guys keep threatening the witnesses. They're talking about Tristan Tate arranging to have people beaten up. It's crazy. So in this video, I'm going to tell you guys about Andrew and Tristan Tate's legal paperwork that they filed to try and get themselves released. And then I'm going to tell you how the government slapped it down, clapped back, beyond all of the evidence that I showed you in the previous video that's actually why they're locked up. They slapped them with a whole new bag of evidence as to why everything that the Tates are asking for is nonsense and should not be allowed. This is going to be another doozy, okay? This is all completely different stuff to the other video. This is basically the Tates' defense and how it failed and got obliterated by the government. The last video was the evidence and the alleged facts of the matter that Tate is potentially going to be serving 20 years to life for. So let's take a look. So this is a declaration signed by Andrew Ford, and basically this is like an attempt to talk their way out of this extradition that is pending, and it's imminent really at this stage, okay? So Andrew Ford made the declaration. He basically says that this is a statement made in connection with the extradition proceedings currently being held in the US, in Florida, concerning the extradition request of Andrew Tate and Tristan Tate by the United Kingdom. He explains that he is the director of Hoban Adams Solicitors in England and Wales. He claims that he's represented Andrew and Tristan Tate in various matters in England since 2022, very familiar with the matters concerning proceedings in that jurisdiction. Specifically, I represent Andrew and Tristan Tate in proceedings regarding 2 trade and cooperation agreement warrants, Appendix 1 and 2, one for Andrew, one for Tristan, and how these warrants were issued by District Judge Goldspring in January 19th, 2024. It explains that Andrew and Tristan were both arrested in Romania in relation to the TACA warrants on March 11th, 2024, and Romanian proceedings were already well established by this date. Following a hearing, the Bucharest Court of Appeal ordered that extradition to the UK would happen, but only after Romanian proceedings had concluded, because these proceedings were commenced prior to the inception of the UK proceedings. That was before the Romanians got compromised and let them swan off all around the world, to Hong Kong, to Dubai, to the United States, to Russia. Ridiculous, okay? And these guys are so dumb, they managed to wriggle their way out of this accountability, and then they went back. They went back to countries with extradition treaties. How fucking dumb do you have to be? Should have stayed in Russia, dummy. Okay? So it says, following a we already had that. So the Crown prosecution is aware of the Romanian order staying extradition. Oh my God, they put it in italics. Well, this is where you fucked up because you went to the United States. Romania ain't got nothing to do with this shit, all right? So it says, in all the communications between my firm, Hoban Adams, on behalf of the Tates and the Crown Prosecution Service, I have been operating on the belief the Tates' extradition to the UK would happen once the Romanian proceedings had concluded. Any suggestion the Tates would have voluntarily returned to the UK after the warrant was issued is at odds with the order by the Bucharest Court of Appeal staying extradition. Well, the UK doesn't give a fuck about the Bucharest Court. Authorities in the UK have acknowledged and expected the Romanian order since it was entered March 2024. Blank! Redacted. I wonder what's redacted. Probably not a good use. And this says refusal by Crown Prosecution Service to provide disclosure. It says, since the warrants were issued, the police and Crown Prosecution Service have not been prepared to provide any further information regarding the allegations other than the scant information provided within the TACA warrants. And since March 14th, 2024, I've written to the Crown Prosecution Service and the police on several occasions to request basic information. Most importantly, the names of the complainants. They don't want to give them to you because you keep threatening them. It's simple. We sought the names of the complainants in order to assist the investigation against Andrew and Tristan. No, it doesn't really assist the investigation. The investigation's been going great without you fuckers. It's going to assist in the intimidation of the witnesses, I believe, specifically by providing further information regarding their relationship with the Tates. These guys are acting dumb. They're acting as dumb as fucking Sam Altman whenever you see him in an interview. Oh, we just want to get to the bottom of we just want to get to the bottom. We just want to know the victims so we can look into the, you guys are fucking R-words, right? The allegations relate to apparent incidents which date back more than a decade, and they were not made contemporaneously, as Andrew travelled to the UK in 2022 without issue. I believe the allegations were made after that time. In England, it is a defence to R-word where one has a reasonable belief in consent. Thus, counsel needs to know the complainant's identities in order to investigate and gather evidence to support the potential defences that sexual contact was consensual. Or get in touch and intimidate them so that they claim retrospectively that they consent so that you can meddle in proceedings. That there was a reasonable belief in consent or that no sexual contact took place at all. Long shot. The Tates sought judicial review of the CPS's refusal to provide the names of the complainants. I've annexed our statement of the grounds from this case, which sets matters out in detail, Appendix 4. The judicial review was heard at the High Court in London on June 23rd, 2026, before Justice Chamberlain. The application was refused, but this decision is now subject to appeals. You got nothing. You got fucking nothing. So it says, alleged defiant unwillingness to participate. Andrew and Tristan have never been interviewed in relation to the allegations underpinning the TACA warrants and now the UK's request for extradition from the US, because you've been ducking it for years. We've offered in correspondence, for example, July 24th, 2025, Appendix 5, to make Andrew and Tristan available for interview in Romania. Giant redacted thing. So these officers have been categorically rejected by the Crown Prosecution Service. To say, therefore, the Tates have demonstrated a defiant unwillingness to participate in judicial proceedings in the UK is entirely inaccurate. You don't get to just decide where and when you chat to the police. You don't get to say, oh, let's just do it on Zoom. You guys are on the run for years. The reality is Andrew and Tristan have been deprived of the opportunity to meaningfully engage in UK proceedings as they've never been afforded sufficient information to do so. Just let us know the victims' names and addresses and phone numbers so that we can intimidate them, please. That's what he said. Should the CPS provide the names of the complainants, we would endeavour to provide evidence to assist the investigation, such as messages, photographs and witness statements, and make representations as to whether or not the evidential test is satisfied. He wants to be the judge, jury and executioner of this fucking trial. Why don't you just give us their names and then we'll get in touch with them and we'll let you know whether the standard for evidence is met? No, they've brought charges. The state the people who actually get to decide whether or not you are being charged with a crime, they've looked at the evidence and said, yeah, you're looking like you did it. Let's take them to trial. You don't get to do that. We would like to speak to the witnesses and decide if this is worthy ourselves. That's not how it works. The Tates fully intend to participate with UK proceedings, but as ordered by the court, only once Romanian proceedings have concluded. No. It said that the extradition from Romania has stayed. You were dumb enough to go to the United States, a country with a very rock-solid extradition treaty, by your own accord. That was dumb as hell. It says Section 198 of the Extradition Act 2003 amended the Bail Act to bring the position for extradition regarding the presumption to bail in line with the position for domestic cases. The position in England and Wales regarding bail pending extradition is now there is a presumption to bail in the UK in extradition cases where the defendant is not convicted, as in the case of relation to Andrew and Tristan Tate. Basically saying they have the general right of bail to accused persons and or others. It says a person to whom this section applies shall be granted bail except as provided Schedule 1 to this Act. Basically it says this applies to anyone who's accused of an offence when they're brought in front of the Magistrates' Court or the Crown Court in the course of proceedings or an offence, or if he applies to the court for bail for a variation of conditions of bail in connection with proceedings. This subsection does not apply as respects proceedings on or after a person's conviction of offence. This section applies to when a person whose extradition is sought in respect of offence, if he when he appears or is brought in a court in the course of connection with extradition proceedings in the respect of the offence, or he applies to a court for bail for the variation of the conditions in bail, but subsection 2 does not apply if the person is alleged to have been convicted of the offence. Basically, what they're trying to say is that, like, we should be allowed to have bail even though we're still fighting the extradition. We haven't even gotten in front of you. A lot of people do get bail for the R-word charge, but you guys are so dumb. You're not going to get bail. You're going to get back to the UK and they're going to say you've swanned around the country and hid in Romania and beyond for 10 plus years. No chance you're getting bail. Idiots. The Extradition Act 2003 provides statutory commentary for Section 198. This sets out below, it basically amends the Bail Act, so extradition proceedings are governed by the bail provisions that apply in other criminal justice proceedings, and basically it extends the presumption in favour of bail in extradition cases where someone is accused of an offence. Currently, the presumption in favour of bail doesn't apply to extradition cases, and these amendments remove this anomaly to bring extradition proceedings in line with other criminal proceedings. In conviction cases, the presumption in favour of bail does not apply. So basically saying, if he's not convicted, they should be allowed to have a bail. Right. The amendments in subsection 6 relate to the situation where someone's been granted bail. In the course of extradition proceedings, a court's given power to withhold bail or vary or impose conditions of bail on the application representing the requesting state in extradition proceedings. They don't really have a shot at getting bail, but this is the best that they can do. It basically says when a person is given bail in the course of extradition proceedings, the effect is that they're subject to the same liability to arrest if they were granted bail under a duty to surrender into custody in the course of a criminal case. So basically, if they fail to surrender as required, they're allowed to have an issued warrant for their arrest. They're basically trying to say, oh, look, all right, let us have bail. All right. And look, obviously, if we break the bail, then you can come and arrest us. All right. If there's a reason to believe that they're likely to break the bail, they may be arrested without warrant by a constable. All right. A constable has the power, if where applicable, a person's surety gives notice in writing that they're unlikely to surrender. If a person is arrested in this manner without a warrant, they must be brought in front of a judge, basically within 24 hours, or a justice of the peace to decide whether the person is granted bail again. Basically, just trying to say that, like, look, come on, you can trust us to get a bail. It says, thus, if the Tates were arrested in the UK for extradition to the United States, they would enjoy a presumption in favour of bail. Our word is a bailable offence in England. If they were charged domestically, the brothers would benefit to a right and a presumption of bail in domestic proceedings, unless there's substantial grounds to believe they might flee. Yes, there is substantial grounds to that. Commit further offences. Yes, there is substantial grounds for that. Or interfere with a witness. Yes, there is absolutely substantial grounds to believe that, based on the paperwork that we read earlier. The court in Andrew and Tristan Tate's case would no doubt consider, among other points, the arguments below. They protracted compliance with Romanian bail conditions at significant expense and inconvenience to them, in doing so as they have travelled from other countries to appear in Romania in accordance with their condition. Basically saying, look, when they were on bail in Romania and they pulled strings with the American administration so that they could swan off around the world, unthinkable, or people couldn't believe that was true. They came back and did their court dates as they promised. That doesn't really fill me with confidence. It says the fact that they're publicly recognisable means that they'll probably, not go on the run. They've complied with UK court orders, such as the recent cost orders and confidential ring orders in relation to individuals who bring civil claims against Andrew. That's ironic because you didn't pay your taxes and you got like around £2 million frozen, so that's bullshit. Lack of previous convictions in any jurisdiction because you got 8 passports who can't fucking find you. Lack of breach of bail conditions in any jurisdiction because you were pulling strings in Romania, in America, to have the Romanians basically let you just absolutely have your run of whatever conditions you wanted and go abroad on bail. And the fact that Andrew and Tristan have been to countries with no extradition treaty with the UK but did not seek to stay there because they're so dumb. If they were smart, they would have stayed in Russia, but they're idiots. Basically, we're idiots, all right? We're idiots, please, okay? So this has kind of got a bunch of appendixes. A lot of this is redacted, so we're not actually able to see what was going on. But what is interesting, okay, is there's kind of some more details that come up on like page 39, I believe. We've already kind of got an idea of what the charges against them were and things like that. But basically, there's kind of some more factual background about the claims against them and essentially what essentially they believe they're facing. So it says the factual background of this case. The claimants are dual citizens of the United States and the United Kingdom. Can't spell the country correctly. Kingdom. Don. D-O-N. The United Kingdom. Okay. This is how good their lawyers are. They can't spell the country correctly. They have been habitually resident in Romania since 2017. I know this wasn't written by that bald lawyer that's running around talking about they didn't do nothing wrong, but it reads like it. Claimants were arrested by Romanian police in Bucharest, December 2022. In June 2023, Romanian prosecutors charged them with the offences of R-word and human trafficking allegedly committed in that jurisdiction. It's like, bro, this doesn't look good. Basically trying to say like, oh no, we couldn't possibly have done this because we were over in Romania human trafficking and R-word and girls. What are you talking about? This is terrible. The criminal charges in Romania are contested by the claimants, and they're due to stand trial in Romania on a date to be confirmed. An arrest warrant for each of the claimants was issued by Westminster Magistrates Court. On the 19th of January 2024, the warrants were issued under the Trade and Cooperation Agreement, TACA, allowing for streamlined extradition proceedings between the UK and member states of the EU. The warrant issued for Andrew Tate had 10 offences, 3 offences of the R-word, 4 offences of assault occasioning actual bodily harm, 2 of human trafficking, and 1 of controlling prostitution for gain. Tristan Tate was accused of 3 counts of the R-word, 6 counts of assault occasioning ABH, and 2 offences of human trafficking. None of the charges on the face of the warrants named a complainant. By way of example, the R-word charges were particularised in the following manner. It says between the 1st of January 2015 and, again, I'm assuming this is UK formatting for dates. So I'm going to say the 3rd of January 2015, unless they're going by American standards. But anyway, he intentionally penetrated the V of a woman with his P, and she didn't consent, and they didn't reasonably believe she was consenting. In the charges that alleged an offence other than R word, the complainants were simply referred to as another in the particulars, hence taking one of the assault charges as an example. Between the 1st and the 3rd of Jan 2015, assaulted another, thereby occasioning her actual bodily harm. On the 12th of March 2024, the Court of Appeal in Bucharest granted the UK's extradition request. The claimants are therefore due to be extradited from Romania to the UK once the criminal proceedings they face there before the courts in Romania have concluded. On the 14th of March 2024, claimant's solicitor, Mr. Andrew Ford, contacted Bedfordshire Police via email to request a document setting out basic case information, including the following: who the complaints are, what they allege, when they made their complaint, whether they had made any previous complaints that had been NFA'd. And he might as well have added on, where do they live, and what are their fears? What are their fears? What are their worst, deepest, darkest fears and secrets that we could exploit? That's basically what he would have loved to say. A response from the OIC, Sam Canner, was received on the 19th of March 2024, which said that regarding disclosure, having just met with CPS colleagues, I'm aware that they will be writing to you. There followed an email from the CPS reviewing lawyer, Miss Catherine Atwell, who also on the 19th of March 2024, Miss Atwell confirmed that the TACA warrants had been issued solely on the basis of the material contained within them, and that no other evidence had been placed before Westminster Magistrates Court. Miss Atwell asserted that the warrants contained sufficient information for the claimants to challenge the extradition progress, and went on to state that with regards to your request for disclosure of the following complainant's identity, when they reported the complaint and previous complaints, I don't intend at this stage to disclose this information. The rationale for this decision was that the claimants had not been charged, although issuing a charging decision had been made on the full code test, and warrants had been issued and were not subject to bail conditions. I think that's an assumption there. I think the rationale for this decision, because you guys have a track record of intimidating witnesses. The claimant solicitors then wrote to Miss Atwell on the 21st of March 2024, noting, previous correspondence we've received regarding disclosure has perhaps erroneously focused on full disclosure of evidence. We make clear we're not seeking full disclosure of the evidence. Our request is just for the type of information that would be provided at pre-interview disclosure. This request enables a suspect to understand the nature of the case against them. Tell us who, give us their names and their addresses and their fears. That's probably what they were thinking, in my opinion. The letter went on to state, you have raised the issue of non-disclosure of the identities of the complainants and their safeguarding. We understand this concern. There's no desire from our side for the public ventilation of their identities. We promise we won't do anything public with their identities like we've done in the past. We provided assurances that we have advised our clients in relation to offences of witness intimidation, the ramifications of publicly naming complainants, witnesses, and the potential harm that this would cause to any defence profit. Sure. Further correspondence between parties. So basically, I'm sure that the UK government said, yeah, nice fucking try, dummy. Nice try, dummy. All right? We promise we won't intimidate these witnesses. Just give us their names and the details. Further correspondence between the parties on other topics also referenced the claimant's request for disclosure of the complainant's identities. The CPS position was to reiterate the mantra in the email of March 19th, 2024. For example, in a letter dated 30th of May, Miss Atwell dealt with the request for disclosure by saying, as stated in my email on the 19th of March, the full code test has been applied. Once extradited to the UK, your clients will appear at Westminster Magistrates Court in relation to the charges. The concerns raised in your letter regarding the application for the full code test are addressed in my email dated 19/03/2024. Basically saying, no more, I'm not going back and forth about this. We already told you we're not giving you that information, so shut up, and you'll get it when you appear in court charged with these crimes. On the 8th of October 2024, the claimant's solicitors again wrote to the Crown seeking the disclosure of basic information equivalent to pre-interview disclosure. The letter included the following statement. An undertaking from our clients not to disclose the complainant's identity provides sufficient protection to the claimants while also balancing the need for ensuring a fair process. Basically saying, oh, pretty please, can you just give it to us? We promise that we won't intimidate them like we've done in the past, allegedly. That's basically what they said. On the 22nd of October 2024, the Crown responded with a letter that refused to provide any additional disclosure and rejected the suggestion of an undertaking. There is reference to a confidence order and a confidentiality order in your correspondence, which are enforced as part of the civil proceedings. However, you will be aware that civil proceedings are separate to criminal proceedings. The offer of an undertaking from your clients not to disclose the complainant's identity would not offer sufficient protection to them because any such agreement would be unenforceable. Basically saying, you creeps saying we promise that we won't intimidate witnesses. That doesn't mean anything. That's not worth a fucking, like, just a piece of toilet paper that I wipe my ass with and I told you it's a contract. That is not anything. That's not sufficient. This is nothing. Unenforceable. But we said pretty please with a cherry on top that we wouldn't intimidate these witnesses like we do all the time. So it said, in order to address the erroneous suggestion that undertakings given by the claimants could not be enforced, a formal offer of undertakings was made under the cover letter dated 23rd of December 2024. In that correspondence, the claimants each offered undertakings backed by a security of £10,000 not to reveal the complainants if they would disclose to them. Oh, pretty please. Pretty please. We'll give you 10 grand. We'll give you, if we intimidate these witnesses, we promise to pay you 10 grand. This guy's making millions a month. What the fuck are you talking about, 10 grand? This guy's a joke. I shall not publish or otherwise reveal to any person any matter related to any of the complainants that is likely to lead to members of the public to identify any complainant as a person against whom an offence is alleged to have been committed. Further, I undertake that I shall not incite, encourage, counsel, or procure any other person to publish any matter relating to the complainants that is likely to lead members of the public to identify any complainant as a person against whom an alleged offence is committed. I promise. Please just tell me their names. On the 8th of January 2025, a response to the offer of undertakings was received from the CPS. The officer rejected and the following reasons were cited. It was fucking nonsense. Your clients are not subject to bail within this jurisdiction. Therefore, there are no legal mechanisms in place in relation to the administration and, if applicable, forfeiture of the monies. Basically, that's not an agreement that you can make or we can make. This isn't a thing. Furthermore, the proposed undertaking and security do not mitigate the risk of harm to the victims. Therefore, it would not be appropriate to enter into such an arrangement. Basically saying that's a load of bullshit. We would never agree to that. Are you dumb? On the 18th of February 2025, the claimant sent a letter before claim in judicial review. What was that? Don't worry what that said. 27th of February 2025, claimants travelled from Romania to the USA. A travel ban that had been imposed by the authorities in Romania and prevented the claimants from leaving that jurisdiction was lifted prior to them travelling to the USA. How? Why? On the 7th of March 2025, a response letter before claim was received from the DPP, Department of Public Prosecutions. On the 21st of March 2025, the claimants left the USA, returned to Romania in compliance with the terms of their judicial control. Both claimants registered with officers of the Romanian Serious Crime Agency DCOT in Bucharest. On the 1st of April 2025, they travelled from Romania to Dubai. On the 24th of July 2025, the claimants again offered undertakings, each with an increased value of £20,000. This is nonsense. This is insane that they're, oh, go on. We'll give you 20. What sort of corrupt backwater third world country do you think the UK is that for 20 grand they'll tell you the names of the victims so that you can intimidate them? The claimants also stated that while that they were willing to assist the investigation by agreeing to be interviewed under caution, notwithstanding a charging decision had already been made. Investigating officers were invited to conduct the interviews under caution in Bucharest with the permission of the Romanian authorities. Oh, go on, come to a completely different jurisdiction and interview me whenever I feel like it. On the 11th of August 2025, a response to the offer of undertakings was provided by the CPS. The officer was obviously rejected, and the following reasons were cited. Whilst you have offered undertakings that your clients will not disclose the complainant's identities and would pay 20 grand if they did so, that's it. Thought you were rich. We do not consider there's any enforceable legal basis for such undertakings, either in this country or more particularly as your clients aren't even in this jurisdiction. Furthermore, the prosecution set out in detail our position on this issue in our response, dated 7th March 2025 to your proposed claim for judicial review and do not propose to repeat that. The claimant's offer to provide the police with interviews under caution was also rejected, but no reasons were cited, because it's a different fucking country. They've got no right to interview you in Romania. Why don't we have an interview in Manila and have the fucking rumble in the jungle? Outside the jurisdiction. Why don't we have the interview in international waters? Because it's not allowed. You can't just go over there and interview people. It's nonsense, all right? The fact that he thought this was going to work is baffling. Absolutely baffling. So it says the claimants are currently under Romanian judicial control, meaning they must regularly meet with prosecutors and are obliged to return to Romania as and when required by the Romanian authorities. Submissions. It's clear that a suspect in a criminal investigation has the right to provide information to the police and that the CPS that might affect the decision about whether the charges should be brought. Here's the funny thing, right? When your travel ban was lifted, if you wanted to sort this out so much, why didn't you fly to England and just have an interview in England under caution? Oh, because you were fleeing these. Because you were fleeing these charges. You don't want to face justice. Oh, okay. You thought you were good in America. The police have a duty to pursue all reasonable lines of inquiry in the course of a criminal investigation, whether they point to or away from a suspect's guilt. If criminal charges are instigated, the defendant may also offer material to the Crown that may have a bearing on what charges should be pursued. The requirement for the police and CPS to consider material put forward by the suspect is rooted in the right to a fair trial, and they basically bring up case law that suggests that you're allowed to bring forward evidence to say, well, this is not true. That's You're trying to do it on your own terms to a level that's so egregious that, like, why would they ever agree to come to Romania and take 20 grand off of you? And whoopsie, oh no. If you renege on your deal, right, and you actually end up intimidating these witnesses, right, the frog and the scorpion story comes to mind. It's just in his Cobra Tate's nature to intimidate witnesses. What the fuck is the UK government going to do with 20 grand? What are they going to do with 20 grand to remedy the situation? You think that British justice can be bought for 20 grand? It's not that cheap. So it says the right of a suspect defendant to provide information, have it considered by those responsible for determining whether charges be brought or continued, is reflected in the Code for Crown Prosecutors. Basically, it says that although prosecutors primarily consider evidence supplied by the police, the suspect or those acting on their behalf may submit evidence or information to the prosecutor before or after the charge to help inform the prosecutor's decision. Here's the funny thing, right? Sure. Just send the evidence that you didn't do the R word to these girls now. Oh, but I need to know who they are so I can intimidate them. I mean, so I can cherry pick the evidence that I send you guys. It's plain as day. What he's trying to do is get the identity of the accuser so that he can threaten them and get them to renege on it, and then that he can then submit evidence that they've reneged on the deal. That's as simple as that, all right? It's axiomatic. Ooh, axiomatic, you say? Axiomatic. Axiomatic. Axiomatic is an adjective that means self-evident, obvious, or unquestionable. It describes a statement, rule, or fact that is so clearly true it doesn't need any proof or argument. And Andrew Tate being an R word. It's axiomatic that in order for a suspect or defendant to be able to provide relevant information, he must be aware of the basic details of the case against him. Accordingly, although the statutory provisions concerning disclosure do not apply before a defendant is brought before a court, the common law requires that adequate disclosure is made. So basically, what? You've done so many R words you can't even remember who's who, and you need us to refresh your memory. It's not really our problem as the British state, is it? So Annex B highlights that in order for pre-charge engagement to be effective and fair, the police and prosecution will of necessity have to provide disclosure. And it says, since pre-charge engagement takes place prior to the institution of any proceedings, the statutory disclosure rules will not be engaged. However, disclosure of unused material must be considered as part of the pre-charge engagement process to ensure discussions are fair and the suspect is not misled as to the strength of the prosecution case. I don't think Tate is being misled about the strength of this case. I think that they're accurately depicting a man who would interfere with witnesses, frankly. The defendant does not appear to dispute the claimants have a right to provide information at the current time that might affect the decision about whether to maintain the charges against them. The CPS has invited the claimants to provide any such information. So exactly like what I said, if you've got proof that you guys don't do the R word on people, give it over. We don't need to tell you who. If you R word so many women all over the world that you've lost track of the ones that you've R-worded, that's really not our problem. So if you or your clients have any additional material you think would have a bearing on the case and support your client's position, please forward the material to the police for consideration. You can't do that because you don't have shit. All you want is the name of the witnesses so you can intimidate them. And you've R-worded so many people that you don't know which victim to intimidate. That's what's going on. You will have a copy of the TACA warrant that provides details of the offending, location of the offending, and summary of the allegations, which is sufficient for you to be able to do this. The invitation was reiterated on the letter dated January the 8th, 2025. The obvious difficulty is the claimants cannot realistically be expected to provide information that has a bearing on the case if they don't know the identity of the accusers. Yes, they can. Yes, they can. If you got an alibi and you weren't there and you didn't do the R word on the girl on these dates, send that. Oh, you can't. Oh, because it's probably true, in my opinion. This renders the invitation to engage the investigation effectively hollow. That's nonsense. The assertion by the defendant that the details provided in TACA warrants are sufficient for the claimants to be able to provide any relevant information to the Crown is wrong and disingenuous. Everything here is disingenuous. The warrants have been drafted in a vague manner to conceal the identities of the complainants. Yes, because you will intimidate them. Because you want to get hold of them, right? The suggestion is the warrants give sufficient details of the location of the alleged offences is plainly incorrect. For example, charges 3 to 6 against Andrew Tate, 2 offences of R-word and 2 of assault occasioning actual bodily harm, were allegedly committed against the second complainant at her home address in the UK. Are you telling me that he went to multiple girls' homes? the same day, and he doesn't know which home he went to. Without knowing the identity of the second complainant, the information provided about the location is next to meaningless. Andrew Tate goes in women's houses and R-words them so often, he doesn't know which fucking victim you're talking about. That could have been any woman's house that I R-worded her in and assaulted her in, right? Further, the timing of the alleged offences appears to have been left deliberately vague. Although the summary within the warrant suggests each of them took place on a single day, the charges particularise with a date range of the 1st of January to the 1st of March 2015. Now, I thought it was from the 1st of January to the 3rd of January, so now they're kind of pulling that one. But what's interesting is they used, I'm pretty sure they were using the UK format of dates. But anyway, let's not get too bogged down in that, because I just don't think that that's actually that serious. But it says the information provided in the warrants is insufficient to permit the claimants to understand the case against them, Cap, or determine whether they're in possession of material that might affect the Crown's decision about whether to proceed with the charges. So they're basically saying, unless you tell us who the victims are so we can intimidate them, we can't possibly, we got no idea what could possibly clear our name. We've got no idea. Please just tell us the name of the victims. This is crazy. It's disgusting. The dates and location given are too vague for the claimants to be able to put forward a positive case by way of alibi, for example. Further, the Crown's failure to provide the names of the complainants mean the claimants cannot know if they're in possession of information that might undermine the credibility of the complainants or the accounts that they have provided to the police. They want to undermine the justice process. In effect, the deliberate decision of the defendant to withhold basic details of the criminal case against the claimants denies them the right to provide relevant material to the Crown and have the charges against them reviewed in light of that evidence. Just send the evidence, bro. Just shut up and send the evidence. You don't have any. Despite suggestions in the letters from the CPS dated 22nd of October 2024 and 8th of January 2025 that the information contained within the TACA warrants is sufficient to permit the claimants to put forward relevant material, the defendant has tacitly acknowledged this not to be the case. In the DPP's letter claimed dated 7th of March 2025, paragraph 20F, it stated the DPP ensured all reasonable lines of inquiry, including insofar as electronic communication and devices are concerned, takes into account the fact that there will be a period of time when the claimants will not be aware of the names of the complainants. All right? The claimants will be not aware of the names of the complainants. It's not apparent in practical terms what this means, but it's clearly predicated on the idea the claimants will not be able to determine complainants' identities from the contents of the TACA warrants. Whatever steps the defendants has taken to mitigate the fact that the claimants can't provide relevant material to the Crown, they're inevitably second best. The investigation and decisions concerning the charges would obviously be better aided by the claimants being able to provide information and suggest further lines of inquiry. Just provide the information, bro. You don't need to intimidate them. Like, you don't need their info. It's nonsense, right? We're going around in circles. Oh, we can't give you we can't clear their names until you tell us who the accusers are. It's just, you are known for intimidating witnesses, okay? It's very specific in this case that you guys are known for intimidating witnesses. So, basically, their decision to not provide details of the case breaches their Crown's common law duties. They're basically just arguing over and over. I'm not going to bore you to death with this, but it's over and over again. It says it's important to note the defendant's decision to not provide basic disclosure at this stage has a potential to cause material prejudice to the claimants and the conduct of their defense in the forthcoming criminal trial. The offences alleged are already against the... Sorry, I'm losing it today. The offences alleged against the claimants are already of some age, ranging between 3rd of July 2014 and 1st of October 2016 in the case of Andrew, and between the 1st of April 2012 and the 1st of October 2016 in the case of Tristan. It's currently unclear how long it will be before criminal proceedings in Romania are concluded, a process that's outside the claimant's control, but it's likely to be many months, all right? It could be years. Without knowing the identities of the complainants, the claimants are unable to apply their minds to the allegation and provide accounts to their solicitors. The delay in their being able to do so inevitably means their memories will continue to fade before their instructions can be taken. So their memories are faded, right? If you could tell me the girl's name and their address and their details so I can intimidate them, it will just jog my memory. My memory will stop fading because currently my memory is just fading. It was fading the whole time that I escaped justice and ran off to Romania for years. It just faded away, right? It just seems like the victims' memories aren't faded because they've suffered great trauma at your hands, so that's good. Further, the claimants are unable to search for, locate or retain potentially important evidence, like electronic evidence, without knowing the names of complainants. There is a risk relevant material that's not currently in the possession of the claimants might be lost prior to their extradition in the UK. See, this one's genius, right? 'Cause it's like, if we don't have the name, we can't look up any evidence in our phones related to this. And, you know, there's a risk that relevant material might be lost prior to their extradition. If you tell us their names, we could look them up on our phones and definitely not delete evidence. We could definitely find out what things are evidence that would make us look bad on our own devices and delete them before the fact. That's definitely not something they would do, right? The defendant's unreasonable decision to withhold the names of the complainants mean the claimants are unable to indicate either to their legal representatives or police what lines of inquiry might be relevant. So look, all right, I'm not just going to go over it. It's just the same thing over and over again. Oh, we just need the information. The complainants have protection of the Sexual Offences Amendment Act. You know, we just need the information. Just tell us who they are. Tell us who they are. Tell us who they are. All right. They just want to know who they are, who they are, who they are. All right. Anyone who was to publish details that might lead to the identifications would commit offence. Basically saying, oh, tell us. It's illegal. We know you guys don't abide by the law. And what's crazy is it's like anyone who published details that would identify the complainants would be subject to an unlimited fine. Well, you guys were only offering 20k. You guys only offered a maximum of 20k for if you accidentally leak this information. Well, it turns out that you're already subject to unlimited fines. So it's just nonsense, right? So basically just saying that, no, we promised we wouldn't do it. We're backing a $20,000 sum that would be forfeit, right, to these multi-millionaires, alleged billionaires. It's crazy, okay? So it's saying the Crown rejected the undertakings offered without explaining why. Well, because it's nonsense. We don't need to waste our breath explaining why. And the letter from CPS in response to the original offer said, your clients are not subject to bail in this jurisdiction. There's no legal mechanisms in place in relation to the administration or, if applicable, forfeiture for the money. Basically saying, look, we're not in business with you. We're not in a relationship with you. We're not in any kind of connection to you, so we can't make this ridiculous like bargain for you to forfeit 20 grand when there's already a maximum fine by law for you leaking this information. So it says the fact the claimants offered a sum of money as an undertaking doesn't address the risks that are here and which are real, right? They're not interested, okay? And then so basically they sum it off by basically saying that, look, social media is an inflated assessment of risk. All right. Basically, both of them are of good character. Well, you've got R-word cases border to border, so that's bullshit. The fact that they're both in civil proceedings where they're accused of similar behaviour alleged by the Crown have not published anything to identify the claimants in that separate case. Well, it's civil, so it's different. The fact the claimants have complied with every requirement of their judicial control in Romania. The fact that while there's nothing to date that's prevented them publicly speculating about the identity of their accusers in the criminal proceeding, neither complainant has done so, because that would basically potentially be a crime, all right? With unlimited fines, as we've just established. Basically saying if they were to publish anything that could lead to it being known, they may basically compromise their potential bail, which they're not going to get anyway. And they basically said the risk of them publicly naming the complainants is low. But intimidating them personally, that's another matter, isn't it? The claimants have gone further and offered in good faith enforceable undertakings not to reveal the identities, backed by a substantial sum of only 20 grand when you're apparently billionaires with yachts being built. And then they basically explain that you know, there's a different context in case law from 1998, and it says kind of basically, long story short, it says if fairness demands disclosure, then a way of ensuring that disclosure will be made must be found. But I think it's fair to deny disclosure because you guys are known for intimidating witnesses, all right? It says it's submitted that the use of undertakings like those that we offered you is a way of ensuring disclosure that both offers protection to the complainants and permits fair disclosure being made. So in conclusion, okay, they're basically saying, despite us proactively trying to engage with the Crown, ignore the fact that we've been literally on the run for over a decade and proposing several ways to move forward, like our ridiculous offer of 20 grand that's not enforceable, to enable a balance between protecting the claimants and the claimants' right to a fair trial. Defendant failed to offer the claimants the same level of engagement, instead dismissing proposals with any real basis or disclosure. These proposals had no basis. It was nonsense, right? So basically they're saying it's a breach of the European Court of Human Rights, okay? Basically saying that defendants' conduct in Wednesbury is unreasonable. It's a breach of their human rights. They invite the court to make an order that the defendant close to the claimant's legal representatives the names. Tell us the names, okay? This didn't go down too well. This didn't go down too well at all, okay? So this basically led to a significant response from the courts, okay, that basically clapped back. So what's interesting is that they want bail while they're awaiting extradition proceedings. And they also want the names of the victims in the UK case. So they're fighting with the UK and the US courts at the same time. So this was a pretty comprehensive response from the government, basically acting on request of the UK government, opposing Andrew and Tristan Tate having a bond, basically. And like, they're just not going for it. They're basically saying he's charged with 42 charges of R-word assault, facilitating exploitation, travel, controlling prostitution, distributing indecent images of young'uns, and extreme pornography. All right. Tristan's got 17 charges of a similar nature. They're all charged in Romania with similar offences to what's going on in the UK, as well as influencing witness statements while they're detained and on release conditions in Romania. The Tates were arrested pursuant to a provisional arrest complaint. And basically, it was only a limited subset of the charges they're facing in the UK. It's expected that they'll provide even more charges in a formal extradition request that's not even due for over a month on September 16th. So they might be getting slapped with more charges by the end of the month, and then they'll be getting extradited. It's going to be an absolute belt to ass moment, okay? And basically saying they can't overcome the strong presumption against bail in international extradition cases. The arguments offered in their motion for release fail to demonstrate the lack of a flight risk, lack of danger to the community, and any special circumstances justifying release. They've basically got nothing. The serious UK charges involve human trafficking and violent R-words, including assaults against multiple victims. They're also charged in Romania that they were intimidating witnesses. They're a clear public safety concern. They're a danger to the public. Okay? It's crazy. All right? It's actually crazy. So they claim that they have multiple passports and identities, excessive wealth, influence in numerous countries, and are stridently unwilling to voluntarily return to face prosecution in the UK. They're a heightened flight risk, right? And this basically breaks down all the backstory. And this is going to be quite similar to what I read you guys in a previous video. So I won't get all the way into it. But pretty much says that the US government's got documents from the UK and Romania, which I broke down those documents in the previous video. So this is like a summary, and there's going to be also some more exhibits that are calling him out. And as you're going to see, there's just a bunch of lies that have been told, basically. So it says the UK submitted a letter which supports an order of detention, providing additional details about the crimes, their unwillingness to return to the UK, having multiple passports, and the means to facilitate flight. Romania submitted 2 letters, which I read you in the previous video, with all the evidence, the ongoing criminal cases, recent charges of witness interference based on alleged conduct that occurred while they were detained under judicial supervision in Romania. You guys are cooked. You guys are fiddling with witnesses whilst you're literally on bail. It's not happening. So the government sets out the current understanding of the procedural history in the UK and Romanian charges against the Tates, as well as facts from those proceedings and relevant issues. So, look, I've broken all of this down in the previous video, but you're going to see more. So I don't need to read you the summary of all the charges that he got all these cam girls on and he made them do stuff for money. But here's where it's crazy, all right? Obviously, the R-word, strangulation, all that kind of stuff. But here's where he gets absolutely cooked. Okay. By the time the 2024 UK charges were issued, the Tates had moved to Romania. Why would they do that? Andrew Tate posted on social media May 3rd, 2020, the UK government tried to destroy me. I was arrested in 2014 and the case was dropped, but they took my phone and laptop and raised 11 new cases. This is when I moved to Romania. I had an apartment in the mountains already paid for, with money inside. Thank fuck I thought ahead. What evidence? What victims? Bro, you fled. You literally fled. You've been on the run for 10 years, blood. In another social media post from December 13, 2019, Tate wrote, England froze my passport and bank about 3 years ago. It's all unfrozen now, but it didn't matter anyway. Romanian passport, jumped on a plane. Bye. Banks, 18 countries, my friends. Hard to kill above the law. In Romania, the Tates continued to encounter other serious legal trouble starting in or around 2022. So they did all the same shit in Romania, all right? The Romanians alleged the criminal conduct took place 2014 to 2022. 46 victims, including minors. Various forms of psychological, in certain cases, physical coercions, intimidation, constant surveillance, control, emotional blackmail, threats, and other means of pressure for the purpose of actually exploiting them. Wait a minute. Andrew Tate physically coercing, trying to control people's mind, constant surveillance. It almost sounds like he's running some sort of matrix. It almost sounds like he is the matrix to these vulnerable women. Fucking hell, all right? The matrix. The matrix is attacking him. He is the matrix. He's a piece of shit. So they were arrested in Romania, put on house arrest. We already know all that, okay? The whole extradition order, we know the backstory on that, all right? Romania basically granted the UK's extradition over their objections, but basically said that, you know, it would be happening afterwards, all right? After the the Romanian charges were dealt with, they would be extradited back to the UK. And what's interesting, even the Romanian judge kind of ruled on the details of the UK charges. Basically, the objections raised by the defense of the requested person regarding the lack of clarity in the description of the accusations are unfounded. The criminal activities in consideration of which the British judicial authorities are requesting the surrender of the requested person, Andrew Tate, presented in the arrest warrant a succinct but explicit, comprehensive manner with a concrete indication of the circumstances, time and place in which they were committed, as well as the manner of which they were committed. They gave loads of information. The fact that the names of the victims are not indicated in the description of the acts presented in the arrest warrant on the basis of which surrender is requested doesn't affect the legality of the procedure. Basically doesn't matter because we've proved enough that you did these horrible things. We don't need to give you the information of these people. You've abused people. We're not letting you do it again. So it was under Romanian law, the extradition was postponed until the Romanian domestic case was dealt with. Okay, they had to deal with the Romanian case, all right, and out of nowhere in 2025 February, the prosecutor removed the travel restriction, so suddenly they were allowed to go abroad. Okay, and part of the reason was cited a considerable delay in the prosecution. The European Court of Human Rights had the right to private and family life. You know, he's apparently got loads of family and kids in Dubai, kids overseas. He was allowed to basically go overseas for that, right? And when all the bombs were dropping in Dubai, he was online talking about my children in Dubai. I'm keeping my family in Dubai. But here we go. Witness interference and intimidation allegations while under consideration. The new Romanian charges, all right? The Romanians basically drafted a letter in July 2026 stating the Tates have fully complied with the obligations imposed on them, appearing to all summons and complying with all measures ordered on each occasion. Okay, and here's the funny thing as well. I said this earlier, right? Despite lifting of their travel restrictions, they didn't go back to the UK. They're permitted to travel freely, even though their excuse is, oh, we couldn't travel to the UK to face these charges. Well, when you could, you didn't. Full of shit. Okay, and also he was obliged. Do not. This is crazy. According to the Tate's evidence, on September the 5th, 2024, the Bucharest Court of Appeal lifted the obligation of Andrew to not communicate with one of the alleged victims. So they basically let him get in touch. That is insane. All right. So even though they confirmed that he appeared for the proceedings as ordered, and the Tates keep saying over and over again, well, look, we turned up to court when we were asked to. Oh, we're not bad guys. Well, two things can be true at once. That's true, but the Romanian authorities are alleging that they took steps to influence victims between January 2023 and July 2024 in pre-trial detention and under judicial supervision. So they tried it even though they were being supervised, okay? And 2 weeks before they were arrested in the US, Romanian authorities announced that they brought new charges against the Tates, but I thought they beat all their charges. It's nonsense, okay? Romania presented the facts, all right, and they basically had witness statements that had been influenced by the Tates. And it basically says that while they were in custody, as well as subsequently under supervision, they basically, during interviews of the victims that were conducted to gather evidence, that the defendants took steps intended to influence them. As we covered in the previous video, they'd got them the same lawyers. They basically persuaded them to not make any statements related to the case, or make false statements, retracting previous statements. They resorted to acts of bribery. They offered money and property, acts of coercion. They made threats, and they disclosed public documents and information regarding the private lives, basically blackmail. These were basically attempted to expose the victims to a wave of threats and online harassment, numerous intimidating messages, death threats sent by supporters of them. Basically, they affected the victims' privacy, safety, and mental well-being to the point where they felt like they couldn't participate in the charges against them. It's despicable. Okay. They apparently attempted to influence 7 witnesses to make false statements, or refrain from making statements, or retract statements. And they were basically only just recently notified of their standing as defendants and of these new charges being brought against them, and they were being hit with new restrictions, right? And then the UK investigation hit them up as well. Okay, basically, following the original charging decision, the UK authorities continued investigating the Tates and announced that they had levied additional charges and obtained new warrants for them. So basically, he's now charged in England with 42 charges. Right, Tristan's charged with 17 charges in England, and it's very, very bad. 7 victims of sexual violence, including the R word, or trafficking. Just horrific stuff. Okay. But here is where it really, really gets bad, all right? Additional facts relevant to detention. The Tate's use of multiple identities to evade law enforcement. They speak and post unabashedly online about possession of multiple passports and his brother's excessive hidden wealth, as well as purported influence over foreign authorities. He claims to have escaped the law on numerous occasions and has unapologetically declared his intent to do so in future. He said, "You can't ban me from driving, I've got 9 licenses. You can't freeze my passport, I have 4. You can't take my money, it's everywhere. It takes international cooperation to slow me down, and that's rare." He said he has 5 passports. He changed his name legally in 3 countries, so his passports all have different names. He's had warrants out for his arrest and travelled freely. "I'm smarter than you. I'm above the law." He said he has passports from Estonia, Nigeria, Poland, the UK, and the US, and 4 more that he's never publicly disclosed. There's evidence that Tristan Tate maintains multiple identities and passports under false names. They found an online post containing a photo of a Mexican passport bearing Tristan's photograph and his date of birth, but it was under the name Vladimir Scorpius. Okay, I believe there is actually a picture of that in Exhibit 9. I've got a few of the exhibits I'll show you at the end. The UK have been unsuccessful tracing the Tate's travel movements. They've not successfully received travel alerts for the Tate's true passports, even though authorities know from social media the Tates have been travelling. UK authorities suspect the Tates may be travelling on unknown passports in their possession. I'm not going to lie, this shit's crazy. I don't know how they pulled this off, but they were never going to get away with this long term. Like, running around the world on different passports evading the government. Bro, this is the government, bro. They're not going for this bullshit. They're not going for it. They're going to get you. All right? Just like YG said, the homies going to get you. The government going to get you. All right? They've also publicly discussed how they've used these documents to evade law enforcement. Tate wrote a post on social media about being on the run from French and German police. He posted a photo of himself on train saying he was always got to escape the hot zone. French and German police after me on 2 different names, heading to Eastern Europe where my connections keep me above the law. Stage 1 is a 6-hour train to escape German borders. He also repeatedly boasted about Spanish authorities. August 29, 2021, he said, "Imagine respecting a Spanish court. That just shows you don't have your life in order. There are 8 different Andrews. I've got 8 lives, 8 licenses, 8 passports." So there's a whole bunch of these, and I talked about these in the previous video. He said, if you can't think fuck the law, then you don't have fuck you money. Bribes, cash bail, expensive lawyers, fines, it doesn't matter. If you have money, the problem vanishes. The law only punishes broke people. That turns out not to be true. The face you make when you try to do a simple car rally and got 3 court cases. Fuck the Spanish, leaving Marbella in protest. They don't deserve my money. Paella eating losers, fueling the jet, next stop. Additional samplings of his declarations of being above the law are in Annex A of Exhibit 1, right? So I believe that exhibit is redacted. So I've got all the unredacted exhibits in a separate document that I'll show you later. But yeah, that one would have been redacted. But anyway, the Tate has basically attempted to identify and intimidate the UK victims, all right? So in spite of every bit of nonsense you heard in the last document, it says, since at least February of 2025, when the travel restrictions were lifted, the Tates have declined to voluntarily appear in the UK, even though they could have gone there. And they've pursued their quest for the identities of the victims in the UK. Okay, see the King on the application of Tate versus Director of Public Prosecutions. I wonder what See the King is. That's very interesting. What is this? The King. The King between the King on the application of Andrew Emery and Twiston Tate and the Director of Public Prosecutions. Is he suing the King? What the hell is this? This is insane. Basically, they're trying to get the information. They're trying to get the claimant's information. So yeah, we get the gist of this, all right? I don't need to go through all this again, but basically they're asking for the info. So similar to Romania, the UK has documented fears of witness intimidation. The UK explained all the complainants in the case of vulnerable and in fear of Andrew and Tristan Tate because of the violence used towards them. Several of the complainants described being assaulted and threatened with weapons, and because of the resources available to Andrew and Tristan Tate, and because of their propensity to intimidate vulnerable witnesses. Relatedly, Tate's own words on social media, Andrew, demonstrate the broad-reaching tools they have to engage in witness intimidation. On September 16th, 2025, Tate posted on his X account with 10 million followers, said 10k reward for this man's identity and workplace. Apparently, the post had 3 million views in less than 10 hours. So they've got a bunch of money, and here's where things get interesting. This is all the new stuff, all right? The Tates are self-proclaimed billionaires who say that they own high-end vehicles, private jets, a custom $50 million super yacht, and have unrestricted access to traditional funds, cryptocurrency, and Bitcoin. The Tates' wealth is often publicly documented by their own videos and statements. For years, the Tates have appeared on podcasts boasting of their unrestricted access to money. For instance, in a 2024 X post, Tristan Tate mocked people who doubted his wealth by posting the blueprints of the super yacht he purchased, which I do actually have here in Exhibit 5. Exhibit 5, all right? This is Exhibit 5 in These Fools Being Cooked. All right, you might have seen this going around. Tristan Tate tweeted, when we purchased the Bugatti, I posted a receipt on Instagram. 25% of the comments told me I was lying. Then it turned up and they all clapped. Now I've purchased a yacht which takes 19 months to construct. Given my record, it's probably best to wait 19 months to look done. So he's claiming it's all his, right? It's his. He's bought this yacht. He owns this yacht, right? Thank you for letting us know that. Thank you for that information. Okay. So obviously he said, well, my super yacht is finished. I'm joining the flotilla. That's what he said. That's what he said when when the super yacht's finished. He said he joining that flotilla, baby. That's what he said. He said, well, my super yacht is finished. I'm joining the flotilla. A flotilla is a small fleet of ships or boats often moving together. The word comes from the Spanish diminutive of fleet. It can refer to a naval unit, local volunteer organization like the Coast Guard, or a group of activists and humanitarian vessels. Naval fleet, a small group of warships. Do you think that he was planning to put together a group of criminals, basically pirates, right? He was going to be roaming the streets, the seas, sorry, right? Trafficking women like a fucking pirate. So as recently as July 14th, 2026, Tristan recorded a walkthrough of their super yacht where he detailed the progress made in the custom furnishings. All right, a tour of my just 70% of my new super yacht. Share the video and follow as Obsidian Blade TV for a chance to win a ticket to the launch party. The Tates have appeared on CEO Cast, a purported entrepreneurial lifestyle podcast where they explain how they live among the top % of society. Okay. CEO Cast, Andrew Tate reveals truth about the Matrix, all right? It was a pretty self-snitching phenomenon. The Tates started their careers as professional kickboxers. Since leaving professional sports, they've begun a webcam porno business in 2014, expanding substantially after they relocated to Romania, and it included dozens of women through an agency called Model Stars. Bro, they're exactly the same as fucking Jeffrey Epstein, all right? As the webcam business wound down, the Tates built an online education business, becoming prominent internet celebrities through courses including Hustlers University, later relaunched as The Real World, and the secretive group known as The War Room. Okay. In August 2023, it was estimated the Tates online ventures generated $5 million in revenue monthly. Wow. Today, a Tate meme coin, Daddy, has a market cap of $7.55 million. The Tate's public presence comes with a heavily documented history of their lavish spending and access to money. They appear in video interviews, podcasts, and post their own social media accounts, which they claim there is nothing left to buy. Each boasts of different luxuries, including diamond-encrusted jewelry, luxury car collections, Ferraris, Lambos, McLarens, elite aviation choices. Andrew Tate detailed he made his millions in an interview with Anthony Pompliano in 2022, basically saying he got his first $2.1 million Aston Martin and $5 and $7 million Bugattis in a self-recorded video posted on the Real World School's Facebook page. It's crazy, all right? It's crazy. So basically, they're going to make this argument that they shouldn't get any bail, right? There's no right to release. They've not met any of the conditions for bails. There's basically special circumstances. They have to demonstrate they're not a flight risk or danger to the community. They can't do that. Even a low flight risk is not enough, all right? Even a low risk of flight. They are a giant, big, fat, steaming, stinky, humongous, gargantuan risk of flight, all right? It says they should be detained as dangerous, all right? They are dangerous, okay? They've allegedly been violent, all right? The charges are related to forcible R words, okay? They're known for being violent. They're known for threatening behavior against victims while detained. And they've been trying to influence witness testimony on an ongoing basis. They're dangerous to the community, all right? They're self-proclaimed flight risks with a history of violating conditions from release. He said that he has 15 driver's licenses. If he's pulled over, he can pull out a license from any random country he wants, all right? He posted about changing his name in multiple countries. Tristan has a fraudulent Mexican passport in this other name as well, all right? We've seen that in the previous video. The Tates have tried to dismiss this as hearsay, but they don't acknowledge hearsay as permissible in extradition proceedings. This is just hearsay. Yeah, we're allowed to use hearsay. Oh, no. Oh, no. All right. To the extent that the Tates claim public social media posts documenting their locations are indicative of their willingness to appear, they're mistaken. First, they could stop posting their locations at any time. Second, the calculation of flight risk changed after they were arrested in the US or informed the UK has dozens of charges with them that carry the possible penalty of 20 years to life imprisonment. Right? It's fucked. So they've shown a propensity for avoiding going to the UK. Specifically, they've mocked and evaded UK proceedings. Uh-oh. All right. He called the UK a joke and total clowns in March 2026. He bragged about never getting extradited and urging the UK to come get him in Hong Kong. Come get me. All right. Okay, we'll come get you. We came to get you. They came and got him. Spoiler, they came and got him. Fucking hell. All right. So basically, he requested the UK suspend the warrant to allow him to return to the UK so he could visit his mother in the UK, which he never did after travel restrictions were lifted. They've demonstrated not just an intent to flee, but repeatedly espoused their wealth, solidifying their means to flee. They're self-proclaimed billionaires who say they owned high-end vehicles and a $50 million super yacht, unrestricted access to traditional funds, crypto and Bitcoin, facts that are glaringly absent from their pleadings. Okay, they have significant financial resources to fund their flight. It's just ridiculous, all right? They got high-end vehicles, private jets, custom yachts, crypto, Bitcoin, bank accounts, residencies all around the world, documented by their own videos and statements. Shouldn't have done all that self-snitching. All right, access to this kind of money certainly necessitates detention, and it renders them serious flight risks. They argue their global visibility demonstrate their inability to go into hiding. This argument is in direct tension with their extensive social media posts where they discuss their ability to avoid detection by using false identity documents in different names. Whoopsie. In any events, the Tate's fame doesn't necessarily mean they could not flee. Of the millions of dedicated followers on their platform, some may be willing to take extraordinary measures to help them hide. Whoopsie doodles. Okay, so they failed to establish any kind of special circumstances, doesn't exist, all right? They claim they complied with conditions in Romania. That's not a special circumstance, okay? They argue there's no greater special circumstance than the fact they went along with Romania's conditions. Well, that's not a special circumstance. That's the bare minimum. If you didn't do that, you'd be in jail. Right? The existence of the Romania extradition order does not support release. Just because there is no, it says they assert there's no diplomatic necessity to detain them because the UK got a surrender order from Romania based on the same warrants. And without citing any law, they argue the UK is seeking to jump the line in front of Romania by seeking their extradition. This argument is flawed. Okay? As of July 2026, the Tates have got new, more serious charges, all right, that are not the subject of any extradition order in Romania or anywhere else. This is all new shit. They've slapped you with some new ones, all right? This is more serious than Romania. The UK's January 2026 charges formed the prior extradition request to Romania, and they basically... Yeah, they don't point to any legal authority that this fact precludes the UK from pursuing their extradition elsewhere. Just because Romania gave them the slip doesn't mean the Americans will do them the same. America and the UK have a pretty well-established relationship, all right? You need to go and learn about the Iraq War and Afghanistan and all the things that the UK, we went along for the ride for America, so they owe us one, basically, all right? And that goes back a very, very long time. They don't present any evidence the UK violated any agreement or order from Romania seeking extradition from the US. To the contrary, the Romanian authorities have assisted with 2 letters to allow the instant US-UK extradition proceedings. They basically said, we can't fucking handle this guy. Take him. Do your thing. Do your thing. We'll take him afterwards. Cook him. All right? It's fucked. So neither delay in seeking extradition nor the availability in bond constitute no special circumstances. Basically, they got nothing, right? They've just got absolutely nothing to go on. Okay, and they're basically just arguing all of this stuff. The victims came forward in 2020 and 2022. They'd already fled the country, all right, and the charges were only brought in January 2024. Okay, so they've been ducking this for years. All right, it's just a fact. It's just obvious. Okay, potential for bail in the UK is not special circumstances. Not going to happen. Never going to happen. All right, alleged due process concerns don't amount to special circumstances. Absolutely no chance. All right, and then this is the really hilarious part that's going viral today. They've been exaggerating the conditions of their confinement, which also don't constitute special circumstances. They've said that their argument the conditions of confinement are so unreasonable it constitutes a special circumstance. That fails. The Bureau of Prisons retains a wide latitude to decide how and where to house the Tates in consideration of their safety and that of other prisoners, staff, and the institution. The Tates' conditions of confinement are not unduly harsh, and they aren't. This is normal jail. There's nothing special about it. The realities of running a penal institution are complex and difficult. The Supreme Court has widely recognised there's deference to be accorded in decisions of prison administrators. Basically, bro, prison ain't meant to be nice. This ain't the fucking Mandarin Oriental Hotel or whatever, okay? Federally, the Bureau of Prisons have been given a statutory authority to determine the location of a prisoner's custody. It's up to them where they put you. You have no say in that, and that's no special... You can't... If you could get bail just because prison isn't nice, everyone would be getting bail 24/7, okay? It's nonsense. No special circumstances. So they're in the special housing unit, the SHU. He's tweeted about that a million times. That's for their own safety and the safety of the institution. Okay, their classification housing placement is not outside the authority's decision making. They can do that if they want to put them in the SHU. Just because they're in the SHU doesn't constitute undue confinement. Now, the fugitives allege their confinement is unreasonable by falsely claiming they've been denied basic needs and access to their counsel. Okay, and this is hilarious, this part. The Tates have been provided with suitable, reasonable housing. They get adequate sleeping arrangements, food, access to water, the ability to order and obtain basic and extra supplies, rec time, social visits, access to phone calls, and visits with their attorneys, often twice a day. All right? Absolutely pretty nice treatment, to be honest with you. Not only do they have basic need and care, but they also get dispensations that other people in there don't usually have. FDC on Miami granted their request for joint meetings with their attorney rather than the one-on-one meetings usually attended by other inmates. So they get to link up, right? They get special exemptions and considerations to commissary that aren't available to other inmates in the SHU because their placement is administrative rather than disciplinary. So they're getting extra stuff on commissary. It's crazy, all right? It's actually crazy. And they're basically, the Tates are consistently allowed out their cell for hours on an almost daily basis for rec times and holding joint meetings with their attorney. So they're linking up, they're getting out of the jail, of their cell. There's no evidence that continued solitary confinement has resulted or would result in their mental decline, nor do they even allege as much. All right? They've basically done everything they can to address their needs. They've ensured their safety. And this is hilarious. Consequently, while FDC Miami is not a Marriott, the Tate's conditions of confinement are reasonable, constitutional, and within the Bureau of Prisons' discretion. Therefore, they do not constitute a special circumstance here. Okay? This prison, it's not meant to be nice, all right? They say they should be released from custody because they might be subject to a lengthy period of detention while they await the submission of the UK's extradition request. That's normal. Some courts have found that unusual delay might constitute a special circumstance, okay? But it must be something beyond factors applicable to all defendants facing extradition. They got 60 days to submit this stuff. That's normal, right? You're going to have to sit down whilst this gets worked out, right? It's not going to be unusually lengthened. And so the brief delay between their arrests and forthcoming submission is misplaced because it's not unique. This happens to everybody, right? This happens to absolutely everybody that's getting extradited. You don't have a good reason, basically. You don't have a good reason. That's not a special circumstance and you're not getting out. That's basically it, right? Through and through. They said they should get out because the UK hasn't provided evidence. No, they've seen the evidence, all right? There's a bunch of evidence. There's more evidence coming. It is what it is, okay? The court said the court should consider probable cause arguments only after the UK has submitted its extradition request, which will contain the documents specified by the treaty. The request may contain additional information and evidence that addresses the Tate's concerns about lack of probable cause raised in their detention brief. It would be premature to base a custody decision on whether they're likely to succeed on a challenge on probable cause at the certification stage of these extradition proceedings. Even if the court entertained their argument on probable cause in these proceedings, the court would reject them as flawed. The premise of their probable cause argument appears to be that the UK charges are based on testimony from unidentified, uncorroborated witnesses. They fail to acknowledge the Romanian court already considered the same warrant in the UK, which also doesn't include the victims' identities. Included there was sufficient evidence to authorize extradition to the UK. So you cooked. Even the Romanians said, no, we don't need their identities. Just because you're salty that you can't intimidate these witnesses doesn't mean shit. Okay. So they basically said that, you know, the UK's are entitled to release because the UK's requests for arrest weren't urgent, right? That's bullshit. Okay. You know, they may require the request pending presentation for the request of extradition. It's basically everything was above board, is basically what this is saying, right? Everything's above board. None of their arguments are working. None of the things they're asking for are actually going well. So that's the end of it. All right. And what's interesting is that there's a couple more sort of pieces of information that came along with this. There was basically a claim. It was this claim that they weren't able to like have good conditions in prison. It says they've been given special exemptions and like their commissary is popping basically. Like they can have hella shit in their commissary. And the government released as an appendix to this all of the things that they bought. All right. All the things that they've bought. They got hella money on their books. Right, so that's Tristan on the left, Andrew on the right. Tristan's got $2,500 on his books. Andrew's got $3,500 on his books. They're scoffing down chips. They've got a bowl with a lid to put the chips on. I thought there was cockroaches crawling all over their face and their food, but no, they've got bowls with lids. They've got chili ramen noodle soup. They've got a clear thermal mug to keep their drink hot or cold. Colombian coffee for $8.85. Spicy sweet chili Doritos. They got a heavy spoon. No, I don't even want to know what they're doing with them spoons. Legal canary tablet. I don't know if that is literally a tablet where you can use an iPad. I'm pretty sure you can get iPads and shit in there. Low sodium ramen chicken soup. They're ordering the same stuff basically, right? Men's speed stick. I guess that's like D-Tick. I don't know what that is. Maybe deodorant. They got ramen, roast chicken, Snickers, turkey and Swiss combo stick. I don't know what that is, honestly. VO5 shampoo and conditioner and body wash. They're in there getting that VO5. They're in there getting that VO5 and they're talking about these are inhumane conditions. It's nonsense, all right? It is absolute nonsense, okay? It's crazy. And then they basically added in all of these stupid false messages that these guys had posted on X, basically claiming they were so hard done by, they were being treated so badly, conditions are so awful. Oh, please, the conditions are so awful. He said, I've received over 800 books, thank you. They told me I'm only allowed 5 at a time, so I won't see many of these, but they must deliver me all mail, so send me letters. In the shoe where my neighbour is picking paint off the wall and eating it, I'm reading All Quiet on the Western Front from the slitter of a sleep lamp that enters my cell, the duality of man. It sounds like you got a tablet in there. He said, I've been getting my letters and packages, not sure what address you're sending them to. Someone sent a successful letter, post the address as a comment. I have thousands. My own cart is just for me. Takes them a while to get organised, much to the staff's dismay. Anyone who wants to send me books on the American Civil War, the Falklands, the real reason for World War I, Duke Ferdinand is BS. Crosswords and Sudoku, no fiction, please. I prefer the real-life action of men who risk their lives for the greater good, the heroes of the past. All right? Thousands of letters received from the UK. They all say that we're heroes, that everyone loves us, and that nobody in the UK believes the government. They're also asking me why the US is treating me this way. I wish I had an answer. Look, it's nonsense, all right? It's nonsense. He's cooked. They're going to send him back, and he's going to get cooked. He's going to get he probably is going to get 20 years for life for the R word. It is crazy, okay? So all of his efforts, all of his attempts to shut this down didn't work. It was a failure. It was an L, and by mid-September, we're going to have even more information, possibly even more charges, and it will be extradition time. He'll be getting shipped back to the UK. There will be no bail. He is a flight risk, and they're going to cook him in the UK. It's going to be insane. So I will see you there. Thank you for watching this long video and the other one. I just wanted to dig into this paperwork for my own purposes. I hope you found that useful and interesting. I'll catch you guys in the next video. I'm out for now.